Yeah, we'll talk about the dissent in this case. Give me a second to get my notes to where they should be. All right. So this case moves to California. And so the background in this case, California ran a workers' compensation / disability program. So if you were injured on the job or something akin, you could get disability. However, the California law in question specifically excluded disabilities that stem from pregnancy, which meant that the state's insurance would not cover pregnant women who had a disability. It's important to note not a small number of women do have pregnancy-related disabilities through the course of their pregnancy. These are temporary disabilities. Some women become immobile. Some women have difficulty breathing. Some women, my wife is a perfect example, in her first pregnancy, not her second, but in her first pregnancy, had morning sickness the entire 9 months and simply could not work for the last 4 months at all. And that was a pregnancy-related disability. It was temporary, it was time-bound. But in California, any of those disabilities that stem directly from pregnancy were not covered by the state's insurance. So women, as sort of a collective action suit, brought suit claiming that this was a violation of the 14th Amendment Equal Protection Clause. The court does not agree with that argument. They say that the exclusion of the state of pregnancy was not invidious discrimination because the classification is not based on gender. The argument that the Supreme Court makes here is that the argue doesn't discriminate between women and men. In fact, men by their very nature would never have this law apply to them, as would the majority of women would never have this law apply to them. That only pregnant women who suffered a pregnancy-related disability would fall under this law. And therefore, it's not a gender-based form of discrimination. That's true, but in the slimmest and most narrow of ways. Justices Brennan, Douglas, and Marshall dissent in this case. And they argue that based upon Reed and Fontiero, an intermediate scrutiny standard is absolutely appropriate to apply to this case, and that the California's classification fails to actually meet that. They argue that this discrimination is obviously on the basis of gender, and that men will never afford this type of discrimination. And it will only ever apply to women. And the mere fact that it only will ever apply to a subset of women is not really at question. The fact that it applies to women exclusively is the question. And the state has no good reason outside of wanting to save money in the terms of disability to not covering these cases. So the dissenters carve out the fact that pregnancy by its very nature is gender-based. And even though this case does not apply, or the law in this question does not apply to all women, it can only apply to women. And therefore, for those in dissent, this has to be considered gender-based discrimination.